Welcome to Topics and Decisions on Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa. We are very pleased to have Mr. Gero Maatz with us today. Gero is a registered European patent attorney and a partner at the German law firm of Grünecker. He has been practicing IP law for more than 20 years and representing clients in a variety of different areas. His particular expertise are in the area of opposition and infringement proceedings. He's also a musician and plays with the Patent Orchestra in Munich. Gero is going to talk to us today about Unified Patent Court and Unitary Patent, topics that are quite important, and we are very much looking forward to his presentation and discussion with him. Gero?
Yeah, Reza, thank you very much. And thank you too, Joe. I'm very, grateful for being invited to this talk today. So yes, as you said, Reza, I am going to talk about the Unified Patent Court and the Unitary Patent today. And I am, trying to tell you what these two things are and how they are related. So if we go to the first slide, this is basically, in a nutshell, what I'm trying to bring across today. So I realize from experience that these two concepts, the Unified Patent Court and the Unitary Patent, seem to lead to confusion outside the tiny world of European IP practitioners. So I'm trying to shed some light into this. So what are these? Well, let's start with the Unitary Patent, or short UP. So as the expression patent tells us, this is a protective right, or it is a patent to be more precise. You could also say that it is a particular kind of patent that is achieved by a new validation system that has become available, in which you can have a single patent with a unitary effect covering, meanwhile, 18 European countries. To be distinguished from this UP is the UPC. The UPC is short for Unified Patent Court. So as the expression court tells us, this is a court. It's not a protective right. And it is the court where European patents are enforced and litigated. So maybe as a mnemonic, it's the last letter in the abbreviation you have to look for. So the P in UP is the unitary patent, and the C in the abbreviation UPC tells you it's a court you're looking at. So here's the agenda for this talk. So I'm going to go into a bit more detail regarding these two concepts, the UP and the UPC. And I will do so by jumping back and forth a little bit between the two. And I hope that this does not lead to extra confusion, but instead, makes the differences, but also the correlation between the two concepts a bit clearer as we go along. So firstly, let's turn to the UP, the Unitary Patent. What is that? Well, I guess you're all familiar with the classical European patent. So the way to obtain a European patent is you go to the EPO, you get your patent granted, and after grant, you decide in which countries to validate this EP patent, meaning in which countries you want this to be or to come into force. So what you end up with is a bundle of national rights. So that is your classical EP patent. Now, the new unitary patent, I have to say it's not entirely new anymore. So the system entered into force on the 1st of January last year. So we have been playing with this for a bit more than a year now. The new unitary patent is granted by the EPO just as the classical patent. There's really no difference between the two until grant of the patent. So that's very simple. It's only after grant when the proprietor decides to obtain protection in the form of a unitary patent that he informs the EPO accordingly. And what he gets is a single uniform patent that covers all participating UPC member countries. So I'm going to show you the countries in detail later. But yeah, as I said, it's presently a list of 18 countries that participate.
Gero, can I say a question about that?
Of course.
So I take it the countries that aren't covered, and I'm sure you'll get to this. I know Spain is one, and I think Poland and the UK. From a prosecution perspective, is it that you file one EPO application and then at grant you decide to jump into the UP and then have nationalized with Spain, et cetera, or is it two separate applications? How does that work?
No, it's the former. So there's really no difference between the two, and you have a single application with the EPO, which you prosecute until grant. You do not need to make any decisions on the validation countries, and it's only upon grant or around the time of grant that you want to, well, decide whether to validate the patent in the form of a UP or in the form of a classical European patent, or both.
In terms of cost saving, in terms of paying for validation and annuities, is there significant cost saving if one goes the path of a unitary patent relative to more classical validation?
Indeed, yes, potentially, I have to say. So the annuities which you pay for a unitary patent are more or less the same as the sum of the four or annuities for the four most popular countries for validation. So in a nutshell, you get 18 countries for the price of 4. But then, of course, it depends on the particular technology and the market of your client, whether it is attractive to have coverage in all 18 countries, or whether maybe 2 or 3 countries would have sufficed anyway.
And are there still requirements for submitting translation of claims in various languages for the unitary patent?
Yes, I will come to that in a second, but yes, there are translation requirements indeed. So maybe at this point, it may suffice to say that certain countries are not coverable by the UP because they do not participate in the system. For example, because they are not a European Union member state. And for those countries, a UP is not available. So you validate the European patent in these countries just as in the past in the form of a classical validation. And then there are these 18 countries which are UPC member states. So for these countries, you can choose whether to, collectively protect your invention in these countries by a unitary patent, or alternatively by selecting all or some countries and protect the invention in the form of a classical European patent. Okay, good. So now let's switch over to the Unified Patent Court. So what is this Unified Patent Court about? The court, the UPC, is a single court that has jurisdiction over all participating UPC member countries, and namely for 2 different kinds of actions. Firstly, for infringement actions, so whether European patents are enforced against infringers, and secondly, regarding validity actions or invalidity actions, to be more precise, against European patents. The court has jurisdiction for all unitary patents and also for classical European patents, unless an opt-out has been declared for these European patents. And I'll come to that in a second. The UPC is set up in a sort of decentralized manner. So there are 2 central divisions and then a variety of local divisions, but I'm going to explain that in more detail later on. So let us turn back to the unitary patent, the protective right again, and let us see how do I obtain a unitary patent. So as we discussed already, the application process is just exactly the same as for the classical EP patent. And as we also discussed, yeah, you don't need to file two separate applications. It's just one single application that you prosecute until grant, as you always did. And only at the time of grant, you can decide to request unitary protection, and the deadline to do so is 1 month after publication of grant. And if you do so, the UP will cover the 18 participating UPC member countries. In order to request UP protection, and that was your question, Reza, you also have to file a translation of the entire patent into a second EU language. So we are no longer talking about the EP or EPO languages, German, French, and English. But here you're free to choose any second language as long as it is a language of a European Union member state. If the patent that was granted is not already in the English language anyway, then this translation has to be into English. But yeah, maybe for your clients, it'll happen more frequently that the European patent is prosecuted and granted in English already. And then you're free to choose any European language as the translation language. So for example, what you can do is, if you also want to have protection in Spain, which, as we discussed, is not a UPC member state, then Spain requires a translation of the entire specification anyway. And you can just take this translation into Spanish and file it along with your UP request to fulfill this requirement. Now, when it comes to annuities, those are paid to the EPO for the unitary patent. And as I also mentioned, they are equivalent to the sum of the annuities for the top 4 most popular validation countries. So now, which countries are the ones I talked about? Which countries are covered by the unitary patent and which countries participate in the UPC system? So on the map, which we see on this slide here, the countries which participate in this system are labeled in blue, and you can see that where the majority of European countries actually does participate in this new system. So currently 18 countries have already ratified the agreements, and the youngest member in this group is Romania, which joined us just 2 weeks ago at the beginning of this month. And then we have a few countries marked in orange which do not participate. So we have non-EU countries which cannot participate. That is Norway, Iceland, the UK, Switzerland, and Turkey, for example. And then there are 3 countries which are actually EU member states, so they can participate if they so want, but they decided not to participate, at least for the time being, and that's Spain, Poland, and Croatia. But yeah, we expect that the group of member states or states that actually do participate in the system does increase from the current list of 18 countries to an expected number of 24 participating countries in the next couple of months. Maybe I should say that for an explanation, the UP and UPC system is based on a special legal constellation that is available for EU member states, for European Union member states. And that is the reason why the countries that do not belong to the European Union cannot participate in this system. So in the next chapter, I'm going to explain that unitary patent, a UP, and a classical European patent, let's call it EP, can indeed peacefully coexist. And I'm also going to explain the legal impact of a so-called opt-out declaration. On the next slide that we see here now, this is a diagram which sort of shows the decision-making progress. So if we start on the left, what you do is you file a European patent application and you prosecute it until grant. And once the EPO decided to grant the patent, the proprietor has to make a first decision. And this decision will be, well, in which countries to actually protect the invention, or in which countries to put the European patent in force. And the first branch at the top shows you the decision for a unitary patent, a UP. So if we go this path, the protection will be via a UP, and it will cover those 18 participating countries. But then alternatively, or in addition to that, you can decide to validate the patent in the classical way. So of course, for the non-UPC member states, marked in orange here, it's only the classical bundle patent that is available. And then in addition to that, there is this path in the middle. So for the UPC member states, you can currently decide to, well, have a classical European patent, but you can decide at the same time that you do not want this classical patent to be subject to the jurisdiction of the UPC. And if you don't want the UPC to have jurisdiction on these classically validated European patents, what you do is you declare an opt-out. Or to look at this from a different perspective, let's assume you decide to validate your European patent, the EP patent, in the classical way for, let's say, Germany. Then if you remain inactive, then the default way will be that the UPC will have jurisdiction on this classically validated EP patent. But if you file an opt-out declaration, then the national courts in Germany will have jurisdiction for this classically validated EP patent. So that is the opt-out declaration. And this opt-out declaration, or the possibility of an opt-out, will be available for a limited transitional period of 7 years from the start of this new system. So as you know, 1 year has already expired. So we've just, maybe 6 years left in which we can file opt-out declarations. This transitional period may be extended, but it's still too early, of course, to say what it will be extended.
So this is just a question. My understanding is that one can request opt-out at the time of the publication of the European application, even before grant. Is there any reason to do so? In fact, to take advantage of the opt-out at that stage?
Well, it doesn't really have any effect until the patent is granted, because obviously you can neither enforce your patent because you don't have any yet, nor can it be subject to an invalidation action before grant. So the UPC, the court, really cannot be invoked prior to grant of the patent. The advantage of doing the opt-out declaration early can be, or typically is, that this enables you to file a batch opt-out declaration for several protective rights at the same time, whether these are granted patents or pending applications, and that's just easier for handling purposes. So that is the advantage. But other than that, no, you can file the opt-out declaration at any time. You can also wait for a couple of years to file an opt-out declaration after grant. So there's no necessity to do this directly upon or after grant. The only caveat is, as soon as, for example, an invalidity action has been filed against the patent centrally with the UPC and the invalidity suit starts, then it's too late to file an opt-out declaration. So you can't pull yourself out of the jurisdiction from the UPC once an invalidation action has been filed.
And also, my understanding is that if you request opt-out, there's still one single opportunity to opt in. Is that correct?
Yes, indeed, that is correct. That is what we see on this next slide here, second bullet point from the bottom, that indeed it is possible to withdraw the opt-out declaration once, and then your within the jurisdiction of the UPC again, but you cannot file a second opt-out declaration anymore. So then you're stuck with the UPC. Yes, that's correct.
Thanks.
Great. Okay. So next, let's look at how unitary patents and classical European patents are enforced. So with a unitary patent, it's quite simple because enforcement is always with the UPC. And this is done by a single court action filed with the UPC. And likewise, of course, if the alleged infringer wants to seek relief by filing an invalidation action, this is also done by a single invalidation action filed with the UPC. For the classical European patent, in relation, of course, to the UPC countries, you have both options. So you can either have jurisdiction by the UPC if no opt-out is declared, and then you have a single court action just as you do with a unitary patent. Or, as we discussed, if you declare the opt-out, then you are within the jurisdiction of the respective national courts again. So these are responsible for any enforcement and invalidation actions. The question is, of course, for the patentee, well, should I seek unitary patent protection or should I avoid it? So what are the pros and cons for the UP? So, of course, one significant advantage for the unitary patent, and that's in fact, well, I think the basic consideration or motivation for this system being established, is that it makes patent enforcement very easy for the patentee because there's just a one-stop enforcement. It's just with the UPC. So that's very simple. And also the system allows the patentee to seek preliminary injunctions on a huge scale for several countries at the same time. And I believe there are some countries that had the instrument of preliminary injunctions before the system, but others didn't have the system. But now it became available for all 18 participating countries. And then, of course, it makes your renewal administration easier. As we discussed, you just pay a single fee every year to the EPO, and that is what keeps your UP alive, instead of having to go to a variety of different national authorities to pay the annuities. And then with respect to predictability, the advantage can be that, well, in particular for countries which in the past did not have a high number of infringement cases, the court decisions in these countries tended to be, well, even less predictable than in countries that, well, actually did have a larger share of the IP litigation. And for these countries, well, it can enhance the predictability of your enforcement to go to the UPC. On the other hand, of course, there may be some disadvantages with having unitary protection. And that is, well, what we call putting all eggs into one basket. So, of course, if a single invalidation action leads to your unitary patent being revoked or at least significantly limited, then of course this can be problematic because a number of countries is affected at the same time. And then another disadvantage is that, unlike with the classical bundle patent, you cannot sort of, well, reduce your annuity payments by abandoning certain countries. So in the classical EP patent, of course, you can decide to drop a number of countries so that in the end you just have let's say 2 or 3 countries left, and you pay annuities only for those. But that is no longer possible with the unitary patent because, well, as it is a unitary right in itself, you just, well, you can either keep the whole thing or abandon it altogether, but you cannot just kick out certain countries in order to reduce your fees.
You know, I have a question here. I mean, in terms of the risk of revocation across all the UPC countries in a single action, That's an interesting issue because on the one hand, I assume that even in the traditional situation, if the patent gets invalidated in a jurisdiction like in Germany, I don't know what the chances are that it will survive in other jurisdictions. But nonetheless, it increases the cost for the challenger in any case to go to all those other jurisdictions. I'm just wondering if you have any comment on that.
Yes, yeah, that's a very good observation. And indeed, you're right. If the classical patent is invalidated in, let's say, Germany, then it's quite likely that this decision will be taken to the other countries, and the courts will, well, maybe inclined to come to a similar decision. However, there is a new or a caveat with the new system, and that is a certain prior art may be available only in individual countries for the classical European patents. And that is the prior art that was filed earlier but published after the time rank of the European patent. But now it will constitute prior art for all UPC member states if the invalidation action is filed with the UPC. So that is, well, an increased risk for the proprietor for a revocation or partial revocation of his patent. Great. Okay, so now we're getting to the final chapter of this presentation, and that is about the structure of this unified patent court. So just to repeat, as we discussed already, the UPC will have exclusive jurisdiction over all unitary patents. So those are always litigated before the UPC. And for classical European patents, well, it depends on whether an opt-out has been filed or not. Now, that means that national courts will still have jurisdiction over the national validations where an opt-out has been declared. For the UK, for example, as they left the EU with Brexit, the UK may not be covered by unitary patent. And well, the same goes for Spain, Poland, and Croatia, which, as I said, decided not to participate. The structure of the court is as followed. They have a court of the first instance, and then above that, a court of appeal. The court of the first instance is split up into a central division and then several local or regional divisions, which are spread across the whole territory. So some countries have one local division. That's where you file an infringement court, for example, infringement action, for example. Some countries have more than one local division. So in Germany, for example, there are 4 local divisions in Düsseldorf, Mannheim, Munich, and Hamburg. And some countries decided to, well, go together. So they have a regional division that covers several countries. The central division has 2 seats. The headquarters is in Paris, and the Paris part of the central division is responsible for dealing with all patents in, well, basically all technical fields, including electronics, biotech, software, physics, and so on, except for the patents relating to mechanical engineering and weapons, I have to say. Those are dealt with in Munich.
Gero, can I ask you a question? So it's interesting to me that you've got, the central division and regional divisions. Is this going to be a situation like we have in the States where there will be forum shopping, where some jurisdictions will seem to be more pro-patent and some, more pro-challenger, so to speak?
Yeah, we'll have to see how the system develops and whether certain, well, let's say local divisions will get a reputation for being more pro-patenty than others. So yeah, that is a development that's possible, of course, but it's too early to say that now.
Are there jurisdictional issues? That is to say, can the patentee enforce or a challenger challenge the patent, or however it's going to go, in whatever region they choose, or is there got to be is there some other analysis that gives you the right to file in certain regions or jurisdictions?
And no, so far you are pretty free to choose where to go, unless you start with an invalidation action against a patent. So that one has to be filed with the central division. So you cannot file that with any of the local divisions.
Okay, great, thanks.
Good. Okay, and then yeah, on this next slide, yeah, the structure of the court is shown again in a graphical representation. So we have the central division in the lower right corner, and on the same level the local or regional divisions. And then above that we have the Court of Appeal that's located in Luxembourg. And for any specific legal questions that go beyond this, the European Court of Justice has the last word. Right, and then we can look at a little statistics. So these are the numbers of the court actions that were filed with the UPC during its first year of existence. So in total, the court received 373 cases, and that includes 134 infringement actions. And it's, well, interesting to see that the large majority of these infringement actions, namely more than 100, have been filed with the German local divisions. So that's Munich, Düsseldorf, Mannheim, and Hamburg. So they received more than 100 infringement actions, and that's followed by 10 that were filed in Paris and 6 with the Nordic or Baltic regional division. In several of these infringement actions, a counterclaim for revocation has been filed. So that happened in about, well, half of the cases. And then there were almost 40, revocation actions that had been filed without a previous infringement action. And as I said before, those had to be filed with the central division. The new UPC also gives the patentee, a few interesting additional instruments like provisional measures or the seeking of evidence, and an order for inspection that can be very interesting. So if you're not entirely sure about whether there is an infringement or not, then you can go to the court and ask for the right to inspect the product or even the premises of the suspected infringer in more detail. And then language-wise, half of the cases was prosecuted in English and followed by German with a share of 44%. So those are the two most popular languages for the UPC actions. Right, and finally, let me just allow me a little advertisement for ourselves. So on this map, you can see the location of the two parts of the central division of the UPC. So as I said, they are located in Paris and Munich, and that is also exactly where two offices, the headquarters and the French branch office of our firm are located. So we are close to the UPC locations, and yeah, we're there to assist you whenever you want to use this new system. Right, and that's basically all at this time. So thank you very much. And yeah, let's see. Do you have any additional questions?
Yes, thank you so much, Gero. This was really informative. My understanding, Gero, is that you yourself have personal experience dealing with UPC, even though it's a young court. So I was wondering if there's anything you would like to share with us regarding your experiences litigating at UPC.
Yes, thank you. Indeed. Yeah, that's correct. So our firm was among the first to file a UPC infringement action on the very first day of the court's existence, so on the 1st of June of last year. And we filed, well, several further infringement actions since then. So indeed, yeah, me and my colleagues participate in the system, and we realize that it really is attractive for patentees in a number of ways. So because, yeah, it's just much more concentrated and you can cover several countries just with one single action, and that really simplifies matters a lot.
Another question, Gero, is that traditionally, from our understanding, discovery rules are very limited in Europe compared to what we have in the US. Are those procedural issues going to be handled substantially similarly at the UPC, or are there going to be any differences, for example, regarding discovery and so forth?
Yeah, that's a good question. So my understanding is that discovery does not play a role as it does in the US. So it's generally not available at the UPC, but on the other hand, it's the plaintiff that has the burden of proof. So he needs to, collect the evidence on his own. With the exception of these circumstances where, the patentee, for example, has difficulties getting access to a particular production site or something. So it's very difficult for him to obtain evidence. And in these cases, the instrument of an on-site inspection will be available for the patentee. And this instrument can also be used, for example, on a trade fair. So that's something that we sometimes do, that we get permission from the court to conduct an on-site inspection on a trade fair, and then go to the infringer's booth, and they have to show their products, and it's even possible to take the products apart. So if you wish, that is some sort of discovery that is available.
Thanks.
Okay, well, that's great. Really, really excellent presentation. Thanks so much, Gero. We really appreciate it.
Thank you, Gero.
You're very welcome. Thank you very much again for involving me here.
If anyone wants to copy the slides, just send us an email and we're happy to share them. And everybody have a great day.